It's Michael.
Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is May 1st, 2025 at 10:29 in the morning. So we're returning from my break to continue the walkthrough of H208 with our legislative council.
Yes, thank you for the break, Mr. Chair. Rick Sagel, Office of Legislative Counsel. We are on page 26, and starting with section 2418, we're done with the exemptions. We're going into the consumer personal data rights portion of the bill. So a consumer shall have the right to confirm whether a controller is processing the consumer's personal data, and if they are, access that data. So remember that website I showed you, right? One of those things was access personal data. This is the language that provides consumers the right to know and then access that data. 2, know whether consumer's personal data is or will be used in any AI system and for what purpose. Obtain from the controller a list of third parties to which the controller has disclosed the consumer's personal data, or if the controller does not maintain this information in a format specific to the consumer, a list of third parties to which the controller has disclosed personal data. 4, correct inaccuracies in the consumer's personal data, taking into account the nature of the data and the purposes of the processing of the consumer's personal data. 5, delete personal data, including derived data, provided by or obtained about the consumer, unless retention of the data is required by law. 6, obtain a copy of the consumer's personal data processed by the controller in a portable and, to the extent technically feasible, readily usable format that allows the consumer to transmit the data to another controller without hindrance. Opt out of the processing of personal data for purposes of A, targeted advertising, B, the sale of personal data, or C, profiling and furtherance of automated decisions that produce legal or similarly significant effects concerning the consumer. Okay. I wonder if this needs to be an and. I'm going to note that. I need to be an and. B1, a consumer may exercise rights under this section by submitting a request to a controller using the method that the controller specifies in the privacy notice under section 2419. A controller shall not require a consumer to create an account for the purpose described in the previous subdivision, but the controller may require the consumer use an account the consumer previously created. A parent or legal guardian may exercise rights under this section on behalf of the parent's child, or on behalf of a child to whom the guardian has legal responsibility. A guardian or conservator may exercise the rights under the section on behalf of a consumer that is subject to a guardianship, conservatorship, or other protective arrangement. A consumer may designate another person to act on the consumer's behalf as their authorized agent for the purpose of exercising their rights. Coming up 5 and 7. The consumer may designate an authorized agent by means of an internet link, browser setting, browser extension, global device setting, or other technology that enables the consumer to exercise their rights under subdivision A5 or A7. Sorry, let me go back. A5 or A7 is up here. So we're talking about deleting data, okay, as being one that you can authorize someone to help you with, or opting out of data. So those are the two that language refers to. C, except as otherwise provided in this chapter, a controller shall comply with a request by a consumer to exercise the consumer's rights authorized pursuant to this chapter as follows. A controller shall respond to the consumer without undue delay, but not later than 45 days after receipt of the request. The controller may extend the response period by 45 additional days when necessary, considering the complexity and number of consumer requests, provided the controller inform the consumer of the extension within that 45-day period and the reason for the extension. If the consumer appointed an agent, the controller shall interact with the agent throughout the process and with the exclusion of a data access request, not require the consumer to be involved in the fulfillment of the request. If the controller declines to take action regarding the consumer's request, the controller shall inform the consumer without undue delay, but not later than 45 days after the receipt of the request, of the justification for declining to take action and instructions for how to appeal the decision. Information provided in response to a consumer request shall be provided by a controller free of charge once per consumer during any 12-month period or after every time the controller makes material changes to the personal data practices and policies.
That extend to the members of the household that could reasonably be like if I make that request
Mhm.
and is that am I entitled to know any information about other individuals in the household, and if so, do those other individuals in the household, are they?
So, good question. If you have been appointed as an agent, or if you have somehow gotten the authority to request that information about your family, then you would be requesting it for several consumers. So each consumer would have that 12-month time frame, right?
I think, okay, make sure.
So if you did just for yourself, and then let's say you're one of your children, you got their authorization to do that, or you're their guardian, whatever, that would not be tied to your 12-month. That would be their own 12-month period. If requests from a consumer are manifestly unfounded, excessive, or repetitive, the controller may charge the consumer a reasonable fee to cover the administrative costs of complying with the request or decline to act on the request. The controller bears the burden of demonstrating the manifestly unfounded, excessive, or repetitive nature of the request. When a controller determines a consumer request is manifestly unfounded, etc., they shall inform the consumer and share the controller's justification prior to disregarding the request or charging the consumer a processing fee. There shall be notice for appeal. If a controller is
there some other section that talks about how to appeal?
Let's see. Yes.
Okay, we can all.
The bills run together. Sometimes I have to double check. Yes, there's a process there.
This may not be the time to ask this, but what request would cause a decline?
Well, it would be up to the controller, right? And they may say that they don't have the data or they don't have the capability to do what the consumer wants for whatever reason. And they would have to give that reason that it's either unfounded, excessive if you make a request every day, right? If you just spam them with requests, they would just have to make that clear that this is what you've done and we can't respond to this.
Maybe this relates to Herb's question, but with the controller bears the burden of demonstrating the manifestly unfounded, etc., demonstrating it to just to the person making the request, or demonstrating it to whoever the appeal would be made to.
Well, it'd be to the consumer. So the consumer would be given a notice that we cannot respond, and they would have to say why. Yeah. And eventually, if the consumer's not satisfied, you would go to the AG potentially, right? So the AG would get involved, and they would say, "This is not manifestly unfounded," right, or whatever they
When
would.
the consumer appeals, that first appeal is to the controller.
Right. Right.
Okay.
Right.
Right.
Mhm. If a controller is unable to authenticate a request to exercise any of the rights afforded under subdivisions A1 through 6 of the section, which are, let's see here, let me make sure I'm in the right place here. Oh, okay, this is going back to up here, the personal data rights. Talking about you have the right to confirm whether they're processing your data, whether they are, but you can opt out, these kind of things. The controller shall not be required to comply with a request to initiate an action pursuant to the section, and shall provide notice to a consumer or the agent that the controller is unable to authenticate the request to exercise the right or rights until the consumer provides additional information reasonably necessary to authenticate the consumer and the consumer's request to exercise their rights. A controller shall not require authentication to exercise an opt-out request, but a controller may deny an opt-out request if the controller has good faith, reasonable, and documented belief that the request is fraudulent. If they believe it's fraudulent, the controller shall send a notice to the person who made the request disclosing that the controller believes the request is fraudulent, why they believe it's fraudulent, and that they shall not comply with it. If it was placed to an agent, both the agent and the person who appointed the agent shall receive the notice. A controller shall not condition the exercise of a right under this section through the use of any false, fictitious, fraudulent, or materially misleading statement or representation, or the employment of any dark pattern. A controller shall establish a process by means of which a consumer may appeal the controller's refusal to take action on a request under subsection B of the section. The controller's process shall allow this is the appeals, the framework we've set here, allow a reasonable period of time after which the consumer receives the controller's refusal within which to appeal, be conspicuously available to consumer, be similar to the manner in which a consumer must submit a request under subsection B, require the controller to approve or deny the appeal within 45 days after the date on which the controller received the appeal, and to notify the consumer in writing of the controller's decision and the reasons for the decision. If they deny the appeal, the notice must provide or specify information that enables the consumer to contact the Attorney General to submit a complaint. Nothing in this section shall be construed to require a controller to reveal a trade secret. In response to a consumer request under subdivision A1, this is the right to know. You may not want this, but just for my purposes, confirm whether a controller is processing your data. Yes. Here we go. In response to a consumer request under subdivision A1 of the section, a controller shall not disclose the following information about a consumer, but shall instead inform the consumer with sufficient particularity that the controller has collected the type of information: your social security number, your driver's license number or other government ID, financial account number, health insurance amount account number, account password, security questions or answers, or biometric data. A controller may use the following types of information to display a contextual advertisement: technical specifications, as are necessary for the ad to be delivered and displayed properly on a given device; a consumer's immediate presence in a geographic area with a radius not smaller than 10 miles, or an area reasonably estimated to include online activity for at least 5,000 users, but not including precise geolocation data; and the consumer's language preferences as inferred from context, browser settings, or user settings. A controller using information pursuant to what we just talked about of the subsection to display a contextual ad shall not use that information to make inferences about a consumer, profile consumer, or for any other purpose, and the controller shall not prohibit a consumer from using technical means to obfuscate or change a consumer's physical location to specify a language preference. So those are the consumer's personal data rights. Okay, section 2419, duties of controllers. A controller shall limit the collection and processing of personal data to what is reasonably necessary and proportionate to provide or maintain a specific product or service requested by a consumer to whom the data pertains, and a communication that is not an ad by the controller to the consumer that is reasonably anticipated within the context of the relationship between the controller and the consumer. Establish, implement, and maintain reasonable administrative, technical, and physical data security practices to protect the confidentiality, integrity, and accessibility of personal data appropriate to the volume and nature of the personal data at issue, including disposing of personal data in accordance with a retention schedule that requires the deletion of personal data when the data is required to be deleted by law or is no longer necessary for the purpose for which the data was collected or processed. and provide an effective mechanism for a consumer to withdraw consent provided pursuant to this chapter. That is at least as easy as the mechanism by which the consumer provided the consent. So B1 concerns minors protections, and if these bills both move, we'll need to maybe consolidate what's in kids code with what is here. We'll need to make sure that we're not contradicting, the kids code data privacy along with this bill, if this bill moves in this form. A controller that offers any online service, product, or feature.
The controller knows is a minor. Would that include the concept or reasonably should know?
It's not. It's sometimes that in the kids code, right, that phrase is used. We include that in that reasonably knew or should have known. This is a knowing standard. Knows as a minor shall A, use reasonable care to avoid any heightened risk of harm to minors caused by processing of personal data in the course of providing the online service, product, or feature. Provide to the minor a conspicuous signal indicating that the controller is collecting the minor's precise geolocation data, and make the signal available to the minor for the entire duration of the collection of their precise geolocation data, and not process the personal data of the minor for the purposes of targeted ads or selling the personal data of a minor. I wonder if this needs to be its own, not process the personal data of a minor for the purposes of targeted advertising or sell. We'll need to look at that. This might need to be its own either subdivision, or are we talking about not processing for the purposes of selling? That needs to be clarified. Page 34. Because the way I read it, this would prohibit the selling of personal data of minors. Okay. Oh, Herb, I was wrong. See, the bills run together. For purposes of the subsection, because in kids code, we don't lay it out this way. It's laid out in a different way. For purposes of the subsection, knows means the controller knew or should have known the consumer is a minor. So just to make sure we all know, I misspoke up here. When we say whom the controller knows, in this limited context, we mean knows or should have known, reasonable standard. So if they have clues that this user was a minor, that they should have known this person was a minor, then they would be held to the standard. Information collected based at the age of the consumer or any age or closely related proxy the business knows or has inferred, derived, attributed to, or associated with the consumer for any purpose, including marketing, advertising, or product development. 3, nothing in this chapter shall be construed to require A, the affirmative collection of any personal data with respect to the age of users that a controller is not already collecting in the normal course of business, or a controller to implement an age gating or age verification functionality. And the reason B is included is because the courts have been fairly clear that you can't require these age gating or age verification systems. That's one of the clearest things they've said about these bills. C, a controller shall not process sensitive data concerning the consumer except when the processing is strictly necessary to provide or maintain a specific product or service requested by the consumer to whom the sensitive data pertains. Shall not sell sensitive data. So very clear thing here, right? That a controller just cannot do that, cannot sell sensitive data. Cannot discriminate or retaliate against a consumer who exercises a right provided to a consumer under this chapter or refuses to consent to the processing of personal data for a separate product or service, including by A, denying goods or services, B, charging different prices or rates for goods or services, or C, providing a different level of quality or selection of goods or services to the consumer. 4, process personal data in violation of state or federal laws that prohibit unlawful discrimination. or except as provided in B, coming up, process the consumer's personal data in a manner that discriminates against individuals or otherwise makes it unavailable the equal enjoyment of goods or services on the basis of an individual's actual perceived race, color, sex, sexual orientation, or gender identity, physical or mental disability, religion, ancestry, or national origin. 5A shall not apply to a private establishment. These are prohibitions against discrimination or segregation in places of public accommodation. Processing for the purpose of controller or processor self-testing to prevent or mitigate unlawful discrimination or otherwise ensure compliance with state or federal law. Or processing for the purpose of diversifying an applicant, participant, or consumer pool.
And second, see if I understand correctly. I'm thinking about line 10, a private establishment, and I'm wondering if I am going back to like, are some first party data collectors? We talked about physical locations. Does that mean the subdivision A does not apply to what happens to you in store? Am I connecting two things that are not really related?
So, right. So a private establishment, that's a fairly unique term. These are, and I need to double check, but these are entities that are members clubs, where you're not, they have different, it's not open to the public,
Okay.
not unlike a store, right?
Thank you.
Yeah.
Okay.
But I'll double check that definition. It's federal law as to,
Yeah.
yeah.
Okay. Thanks.
D, subsections A through C of this section shall not be construed to require a controller to provide a good or service that requires personal data from a consumer that the controller does not collect or maintain, or prohibit a controller from offering a different price, rate, level of quality, or selection of goods or services to a consumer, including an offer for no fee or charge in connection with a consumer's participation with consent in a financial incentive program, such as a bona fide loyalty, rewards, premium features, discount, or club card program, provided the controller may not transfer personal data to a third party as a part of the program unless A, the transfer is necessary to enable the third party to provide a benefit to which the consumer is entitled, and B, the terms of the program clearly disclose that personal data will be transferred to the third party or to a category of third parties to which the third party belongs, and the third party uses personal data only for purposes of facilitating the benefit to which the consumer is entitled, and does not process or transfer the personal data for any other purpose. The sale of personal data shall not be considered functionally necessary to provide a financial incentive program. A controller shall not use financial incentive practices that are unjust, unreasonable, coercive, or usurious in nature. A controller that shall provide to consumers a reasonably accessible, clear, and meaningful privacy notice that, this one, I will let you all read this one. This is, it's important, but this goes on for a while. It's a privacy notice and it's important to read, but it's not the most critical part of the bill. So F1, I urge you to read on your own. If the chair is okay with that, it's language that is required to be in a controller privacy notice. I can read it.
Eddie, what is your? Reading it on your own?
I know you all love to read privacy practices whenever you remember something, but this would be required that they have to have in their privacy language. I would flag something that stands out, but I'll double check, but 2, so skipping down to page 39, the privacy notice shall adhere to the accessibility and usability guidelines under federal law, the ADA and the Rehabilitation Act of 73, including ensuring readability for individuals with disabilities across various screen resolutions and devices, and employing design practices that facilitate easy comprehension and navigation for all users. When they make a material change to the privacy notice or practice, you must notify consumers affected by this change and provide an opportunity for consumers to withdraw consent to any further materially different transfer of previously collected personal data under the change policy. They shall take all reasonable electronic measures to provide notification. taking into account available technology. A controller is not required to provide a separate Vermont-specific privacy notice or section of a privacy notice if the controller's general privacy notice contains all the information required by the subsection. They can, use a hyperlink using the word privacy or surveillance. A controller that does not operate a website shall make the privacy notice conspicuously available to consumers through a medium regularly used by the controller to interact with consumers, including email. So subsection J under F1 into the privacy notice must provide a clear and conspicuous description of any processing of personal data in which the controller engages for the purposes of target advertising, the sale of personal data to third parties, or profiling the consumer in furtherance of decisions that produce legal or similarly significant effects concerning the consumer. Here's that definition, and a procedure by which the consumer may opt out of this type of processing. So J is required, and if you go down to G on top of page 41, the method or methods under which that subdivision, a controller must take into account the ways in which consumers normally interact with the controller, the need for security and reliability in communications related to the request, and the controller's ability to authenticate the identity of the consumer that makes the request. Provide a clear and conspicuous link to a website where the consumer or their agent may opt out from a controller's processing of the consumer's personal data. If the controller does not have capacity needed for linking to a web page, provide another method the consumer can use to opt out. And allow a consumer or authorized agent to send a signal to the controller that indicates the consumer's preference to opt out of the sale of personal data or targeted advertising. That is consumer friendly and easy for an average consumer to use. Enables the controller to reasonably determine whether the consumer has made a legitimate request to opt out. Use of a IP address to estimate the consumer's location may be considered sufficient to accurately determine residency. Finally, if a consumer or authorized agent uses a method under that subdivision to opt out, and the decision conflicts with the consumer's existing controller-specific privacy setting or voluntary participation in a bona fide reward program, the controller shall comply with the consumer's opt-out preference, but may notify the consumer of the conflict and provide the consumer with a choice to confirm the controller-specific privacy setting or participation. So this kind of makes clear that if you as a consumer have indicated previously that you don't opt out because you sign up for a program where you get discounts, but then you later on opt out through their opt-out procedure that they provide, that the controller must opt you out, but then notify you, hey, you earlier opted in, now you're opting out, just letting you know that you change your mind. Okay, so that was the duties of controllers.
So, does this get at sort of effective date stuff in terms of when a bill would be enacted and what a consumer had indicated before?
The effective dates come up later, but this specific subsection, not really. Once the bill's effective, let's say July 1st, 2025, again, this hypothetically speaking, if the bill's effective on that date and compliance is required on that date, then, if the consumer had opted in on January 1st, 2025, they would still have opted into this advertising or whatever program they're in, right? If they then opt out on July 2nd, 2025, the controller would have to notify them that, earlier you did opt in, now you've opted out. We're going to opt you out. However, we've noticed that we just want you to be aware that you're changing your decision.
The decision of the consumer to not opt out, I guess, would control if they had done that before.
Right.
Yeah.
Right, but then if they opt out after, then
Right.
Yeah.
No, thank you.
yeah, sure. 2420, duties of processors. A processor shall adhere to a controller's instructions and shall assist the controller in meeting the controller's obligations under the chapter. In assisting the controller, the processor must One, enable the controller to respond to requests from consumers pursuant to 2418B. 18B, because these things are important. So this is the personal rights of consumers. So this is the a consumer may exercise rights under the section by submitting a request to controller using the methods the controller specifies under their privacy notice. So back down to 24. 20. So enable the controller to respond to requests. So consumer requests something be done with their data. Take into account how the processor processes personal data and the information available to the processor, and use appropriate technical and organizational measures to the extent reasonably practicable. 2, adopt administrative, technical, and physical safeguards that are reasonably designed to protect the security and confidentiality of the personal data the processor processes, taking into account how the processor processes the personal data and the information available to the processor. And provide information reasonably necessary for the controller to conduct and document data protection assessments. Processing by a processor must be governed by a contract between the controller and the processor. The contract must be valid and binding on both parties, set forth clear instructions for the processing, the nature and purpose of processing, the type of data that is subject to the processing, limitations and duration of the processing. Specify the rights and obligations of both parties with respect to the subject matter of the contract. Ensure that each person that processes personal data is subject to the duty of confidentiality with respect to the personal data. Require the processor to delete the personal data or return the personal data to the controller at the controller's direction or at the end of the provision of services, unless a law requires the processor to retain the data. Require the processor to make available to the controller at the request all information the controller needs to verify that the processor has complied with all obligations under the chapter. Require the processor to enter into a subcontract with the person the processor engages to assist with the processing personal data on the controller's behalf, and in the subcontract, require the subcontractor to meet the processor's obligations concerning personal data. So I hope you see what's going on here. The controllers are the ones typically subject to the requirements of the bill, but oftentimes the work is done by processors. So processors have to assist controllers in fulfilling the duties of the law. So in this case, you require a contract and you require the processor to help the controller fulfill their obligations of the law, including subcontracts with processors. Yeah. Because processors may hire another processor to process. Allow the controller, 8A, allow the controller's designee, or a qualified and independent person the processor engages in accordance with an appropriate and accepted control standard, framework, or procedure to assess the processor's policies and technical and organizational measures for complying with the processor's obligations under this chapter. Require the processor to cooperate with the assessment. And at the controller's request, report the results of the assessment to the controller. Prohibit the processor from combining personal data obtained from the controller with personal data that the processor A receives from or on behalf of another controller or person, or collects directly from an individual, and require the processor to adhere to equivalent or greater de-identification standards.
Could I go back to the subcontract, Sarah? Within the framework of the bill, why is there a requirement of a subcontract? I can understand that there might be a subcontract.
Because I think the intention is to close a potential loophole, right? That you have the controller and a processor that have to have a contract, right? So if a processor needs to hire another processor to fulfill its obligations under the main contract, they may have their own. We want there to be, well, the bill wants there to be a contract between the two processors.
Okay, so it really kind of means, require the processor to enter into a subcontract with any person the processor engages with. They might not need a subcontract.
They may not. But if they do, then they would have to have a contract. Again, I think it's a loophole that it potentially exists.
Yeah.
C, this,
I understand the reasoning for all the contracts. But ultimately, if something goes wrong, who is the responsible party?
typically the controller. Controller, because they're directing the processing of the data, right?
So if something legally, the AG goes after the controller. The controller can then civilly go after the processor. If they did, whatever they did
Right.
at the controller level.
There could be a third party claim, right? So you could have a lawsuit and the AG sues a controller and the controller says, hey, we didn't do anything wrong. This is our processor did not obey the terms of our contract. So we're going to bring them in as a third party and they're going to be subject to potentially the lawsuit.
Instead of the controller.
Well, right, it would be handled at the court level. Yes.
Yeah, but it would, if it was something the processor did, the responsibility falls on the processor, not on the controller.
Could be. It depends on the facts, but yes, it could.
Yeah, so,
Yes.
I mean, if that's the way, if that's the way it did happen.
Right.
So in it's the protection for the controller.
Right. And at the end of the day, the consumer, because if the
Right.
consumer wants to hold, and the state, if the consumer wants to hold the controller accountable, the controller says, hey, we did everything right. It's the processor that screwed up. Then the consumer would be out of luck and the state would be out of luck unless you had a provision saying that, no, you had to have a contract that says these terms must be adhered to. C, the section does not relieve a controller or processor from any liability that accrues under this chapter as a result of the controller or processor's actions in processing personal data. So that kind of sums up what we're talking about here. That just because a controller is contracting out some of these duties, you still are subject to the law and make sure you follow the law. There are times where you may not be at fault, but this does not give you an out of following the law.
Right.
As it's written.
And it could be the controller has knowledge that the processor is not doing things right.
Right.
And didn't do anything about it.
Yeah. And so D actually speaks to some of these things that we're talking about. For purposes of determining obligation under this chapter, a person is a controller with respect to processing a set of personal data and is subject to enforcement, which we'll get to punish a violation of this chapter if the person A, does not adhere to a controller's instructions to process the personal data, or begins at any point to determine the purposes and means for processing the personal data alone or in concert with other person. So this is also meant to ensure that sometimes, I've mentioned before, controllers and processors are the same entity. And a processor could easily become a controller by the actions that they undertake. So this clarifies that you may claim to be a processor, but you could also, if you're doing things that make you a controller, you're a controller, and you can be held accountable as a controller under this law. 2, a determination under the subsection is a fact-based determination that must take account of the context in which a set of personal data is processed. A processor that adheres to a controller's instructions with respect to a specific processing of personal data remains a processor. They don't remain immune to liability, but they're not going to be a controller. Okay, so if a processor just does processing work, but they do it wrong, they violate something in the contract with the controller, they can be liable, right? But they're not going to be a controller. They're still a processor. 2421 are the data protection assessments, and this is done so the entity itself, the controller, is aware maybe that they do their own kind of self-assessments of what they're doing. And these could be requested by the AG. So the AG knows potentially what the processor, what the controller is doing that could be harmful potentially. A controller shall conduct and document a data protection assessment for each of the controller's processing activities that presents a heightened risk of harm to a consumer, for which the purpose of this section includes 1, the processing of personal data for the purposes of targeted ads. 2, the sale of personal data. 3, The processing of personal data for the purposes of profiling, where the profiling presents a reasonably foreseeable risk of A, unfair or deceptive treatment or unlawful desperate impact on consumers, financial, physical, or reputational injury to consumers, a physical or other intrusion upon the solitude or seclusion, or the private affairs or concerns of consumers where the intrusion would be offensive to a reasonable person, or catch-all other substantial injury to consumers, and the processing of of sensitive data. So these four things here are maybe seen as the most high-risk things that a controller can do to data. So these four things are what the controllers would assess in their data protection assessments. Data protection assessments conducted pursuant to the subsection we discussed shall A, identify the categories of personal data processed, the purposes for processing personal data, and whether the personal data is being transferred to third parties, and identify and weigh the benefits that may flow directly and indirectly from the processing to the controller, the consumer, other stakeholders, and the public against the potential risks to the consumer associated with the processing as mitigated by safeguards that can be employed by the controller to reduce the risks. 2, the controller shall factor into any data protection assessment the use of de-identified data and the reasonable expectations of consumers, as well as the context of the processing and the relationship between the controller and the consumer whose personal data will be processed. The AG may require that a controller disclose any of these assessments that is relevant to an investigation conducted by the AG. So right there has to be an investigation in order to get these assessments. And they shall make them available if requested by the AG. The AG may evaluate the data assessment for compliance with the responsibilities set forth in this chapter. Data protection assessment shall be confidential and shall be exempt from disclosure under the Public Records Act. To the extent any information contained in a data protection assessment disclosed to the AG includes information subject to attorney-client privilege, shall not constitute a waiver. A single assessment may address a comparable set of processing operations that present a similar heightened risk of harm. If a controller conducts a data protection assessment for the purpose of complying with another applicable law or regulation, the data protection assessment shall be deemed to satisfy the requirements established in the section, similar to the privacy notice, right? If they make a privacy notice that is similar to what other states require, then that would be sufficient. A controller shall update the data protection assessment as often as appropriate, considering the type, amount, and sensitivity of personal data collected or processed and the level of risk presented by the processing throughout the processing activity lifestyle in order to monitor for harm caused by the processing and adjust safeguards accordingly, and ensure that data protection and privacy are considered as the controller makes new decisions with respect to the processing. A controller shall retain for at least 3 years all data protection assessments conducts under the section.
Is there any part of the bill that talks about the Attorney General's authority to request data from processors?
No. You mean the assessment or just data? Only controllers have
Any information?
only controllers have to do the assessments.
Yeah, I understand that.
So if there was an investigation, the AG might be able to request certain things from a processor, but that would be, subject to the AG's rulemaking authority, anything else that they can think is relevant for the investigation. But the bill does not spell that out.
Okay.
De-identified data, a controller in possession of de-identified data shall take reasonable measures to ensure the data cannot be used to re-identify an identified or identifiable individual or be associated with an individual or device that identifies or is linked or reasonably linkable to an individual or household. Publicly commit to maintaining and using de-identified data without attempting to re-identify the data. Contractually obligate any recipients of the de-identified data to comply with the provisions of this chapter. The section does not prohibit a controller from attempting to re-identify de-identified data solely for the purpose of testing the controller's methods for de-identifying data. This chapter shall not be construed to require a controller or processor to re-identify, de-identify data, or maintain data in an identifiable form, or collect, obtain, retain, or access any data or technology in order to associate a consumer with personal data in order to authenticate a consumer's request. We have two ors here. I'll fix that. Second or should be the first or. Comply with an authenticated consumer rights request if the controller A is not reasonably capable of associating the request with the personal data, or it would be unreasonable, burdensome for the controller to associate the request with the personal data, and does not use the personal data to recognize or respond to the specific consumer who is the subject of the personal data, or associate the personal data with the other personal data about the same specific consumer. A controller that discloses or transfers de-identified data shall exercise reasonable oversight to monitor compliance with any contractual commitments to which the de-identified data is subject, and shall take appropriate steps to address any breaches of those contractual commitments. Okay, section 2423, construction of the duties of controllers and processors. This chapter shall not be construed to restrict a controller's, processor's, or consumer health data controller's ability to comply with federal, state, or municipal laws, ordinances, or regulations, except as prohibited by 1 VSA 150, comply with a civil, criminal, or regulatory inquiry, investigation, subpoena, or summons by federal, state, municipal, or other governmental authority, cooperate with law enforcement concerning conduct or activity that the controller, processor, or consumer health data controller reasonably and in good faith believes may violate federal, state, or municipal laws, ordinances, or regulations. Carry out obligations under a contract under subsection 2420B of this title for a federal or state agency or local unit of government. Investigate, establish, exercise, prepare for, defend legal claims. Provide a product or service specifically requested by the consumer to whom the personal data pertains consistent with section 2419. Perform under a contract to which a consumer is a party, including fulfilling the terms of a written warranty. Take steps at the request of a consumer prior to entering into a contract. Take immediate steps to protect an interest that is essential for the life or physical safety of the consumer or another individual, and where the processing cannot be manifestly based on an illegal basis. Protect, detect, prevent, detect, protect against, or respond to a network security or physical security incident. Prevent, detect, protect against, or respond to identity theft, fraud, harassment, malicious, or deceptive activity, or any criminal activity targeted at or involving the controller or processor or its services. Preserve the integrity or security of systems, or investigate, report, or prosecute those responsible for the action. Assist another controller, processor, consumer health data controller, or third party with any of the obligations of the chapter. Process personal data for reasons of public interest in the area of public health, community health, or population health, but solely to the extent that the processing is A, subject to suitable and specific measures to safeguard the rights of the consumer whose personal data is being processed, and under the responsibility of a professional subject to confidentiality obligations under federal, state, or local law. Effectuate a product recall or process personal data previously collected in accordance with this chapter such that the personal data becomes de-identified, including to conduct personal research, conduct internal research, develop, improve, or repair products, services, technology, identify and repair technical errors that impair existing or intended functionality, perform internal operations that are reasonably aligned with the expectations of the consumer or reasonably anticipated based on the consumer's existing relationship with the controller, or are otherwise compatible with processing data in furtherance of the provision of a product or service specifically requested by a consumer or the performance of a contract to which consumer is a party. Or conduct a public or peer-reviewed scientific, historical, or statistical research project that is in the public interest and adheres to all relevant laws and regulations governing such research, including regulations for the protection of human subjects. The obligations imposed on controllers, processors, or consumer health data controllers under this chapter shall not apply where compliance by the controller, processor, or consumer health data controller with this chapter would violate an evidentiary privilege. This chapter shall not be construed to prevent a controller, processor, or consumer health data controller from providing personal data concerning a consumer to a person covered by an evidentiary privilege under laws of the state. Nothing in the chapter modifies this law that authorized the use of facial recognition by law enforcement. C1, a controller, processor, or consumer health data controller that discloses personal data.
Rich, when we're talking about de-identified information that then is used when they're re-identified.
Yeah.
For certain purposes.
Yeah.
Is there a requirement that when they're done with those purposes, that they do identify the information again?
There is language that discloses or transfers. Bless you. So if they re-identify it.
Yeah. And for, either they're checking their systems out or whatever,
Right.
but is there a requirement to then de-identify the information again?
I don't know. Because I'm looking at, the subsection D here in 2422, a controller that discloses or transfers de-identified data. That's not re-identified. Okay, but yeah, I'll have to double check that. Okay. So if it's data that's been re-identified, does the controller have an obligation to then de-identify?
Yes. Once they've finished doing whatever they needed to do.
Okay, back to. And so this, the section title is construction of duties. This is also kind of a limitation section. What the chapter shall not, it's limiting certain things. If that's another way to think about it. So we are C1. A controller, processor, or consumer health data controller that discloses personal data to a processor or third-party controller pursuant to this chapter should not be deemed to have violated the chapter if the third party or processor that receives and processes the data violates the chapter, provided at the time the disclosing controller, processor, consumer health data controller disclosed the data, did not have actual knowledge that the receiving processor, third-party controller would violate this chapter. So if there is a situation where a controller is subject to the law or a processor, then legally, lawfully discloses personal data to a third party, and that third party then violates this chapter, the original controller that had no idea that that third party was going to do that would not be liable under this chapter. So it's a little bit different than having a contract between a controller and a processor, right? Here you have potentially, when it comes to a third-party controller, that they would be independently liable for this. Although I'm going to double check this because presumably they have a contract. The controller would have a contract with the processor. So if the processor violates this chapter, provided at the time the disclosing controller processor did not have actual knowledge that they violated this chapter. I only think about that because that to me would, if the processor does something that violates a chapter, the controller could just say, we didn't know they were going to do this. They acted rogue. They did something that we didn't know they were doing. So maybe not a big problem, but just so you all know, this could be a way that a controller would say, we're not liable because we didn't have knowledge that they were going to violate the chapter. We didn't know they were going to sell sensitive data. We didn't know they were going to do targeted ads, right? So let me think about this some too. I'm not sure if this conflicts with the provision that require a contract between the. C2, a third-party controller or processor receiving personal data from a controller, processor, consumer health data controller in compliance with this chapter is not in violation of the chapter for the transgressions of the controller, processor, consumer health data controller from which the third-party controller or processor receives the personal data. So again, I'm going to double check these provisions here. D, this chapter shall not be construed to impose any obligation on a controller, processor, or consumer health data controller that adversely affects the rights or freedoms of any person, including freedom of speech, freedom of press. Well, VSA 615, I'm 1615. I at one point knew that statute. I'm having trouble. If somebody wants to pull it up, they can. Apply to any person's processing of personal data in the course of the person's solely personal or household activities. 3, require an independent school or private institution of higher education.
The Shield law, Rick.
Oh, the Shield law, thank you. So medical decisions, those kind of things. To delete personal data or opt out of processing personal data that would unreasonably interfere with the provision of education services by or the ordinary operation of the school or institution. 4, require for employee data deletion of personal data that would unreasonably interfere with the ordinary business operations of the controller or unreasonably adversely affect the rights of another employee, including on this chapter or pursuant to the protections set forth in 21 VSA Chapter 5. 5, require for processors acting on behalf of a federal, state, tribal, or local government entity deletion of personal data or opt out of the processing of personal data that would unreasonably interfere with the provision of government services by or the ordinary operation of a government entity. E1, personal data processed by a controller or consumer health data controller pursuant to the section may be processed to the extent that the processing is reasonably necessary and proportionate to the purposes listed in the section, or in the case of sensitive data, strictly necessary for the purposes listed in the section. Adequate, relevant, and limited to what is necessary in relation to the specific purposes listed in the section. And compliant with the anti-discrimination provisions set forth in a previous subdivision. Personal data collected, used, or retained shall, where applicable, take into account the nature and purpose or purposes of the collection, use, or retention. Personal data collected, used, or retained shall be subject to reasonable administrative, technical, and physical measures to protect the confidentiality, integrity, and accessibility of the personal data and to reduce reasonably foreseeable risks of harm to consumers relating to the collection, use, or retention of personal data. If the controller or consumer health data controller processes personal data pursuant to an exemption in the section, the controller or consumer health data controller bears the burden of demonstrating that the processing qualifies for the exemption and complies with the requirements in subsection E. This chapter shall not be construed to require a controller, processor, or consumer health data controller to implement an age verification or age gating system. 2424, enforcement and the AG's powers. A person who violates this chapter or rules adopted pursuant to this chapter commits an unfair and deceptive act in commerce. This is the Vermont Consumer Protection Act. And the AG shall have the exclusive authority to enforce such violations except as provided in subsection D of this section. The AG has the same authority to adopt rules, implement the provisions. This is standard language in every consumer protection law. C1, if the AG determines that a violation of this chapter or rules adopted.
So in connection with B, am I correct in assuming that the AG If they're conducting a civil investigation, they bear the cost, the expenses of the office.
Correct. If the AG determines that a violation, instead of the consumer, is that what you're referring to?
No, it's, well, I'm just thinking of the expenses of the AG in conducting an investigation.
Oh.
They bear the cost.
Yes, yeah. If the C1, if the AG determines that a violation of the chapter or rules adopted may be cured, the AG may, prior to initiating any action for the violation, issue a notice of violation, extending a 60-day cure period to the controller, processor, or consumer health data controller alleged to have violated the chapter or rules adopted pursuant to this chapter. The AG may, in determining whether to grant a controller, processor, or consumer health data controller the opportunity to cure an alleged violation, may consider several things: the number of violations, the size and complexity of the controller, processor, or consumer health data controller, the nature and extent of the controller's, processor's, consumer health data controller's processing activities, the substantial likelihood of injury to the public, the safety of persons or property, whether the alleged violation was likely caused by human or technical error, and the sensitivity of the data. Okay, so this enforcement does contain a limited private right of action, and that's D1. You'll notice back in A that, except as provided in subsection D. So the AG has almost complete authority to enforce except what is in D1 or in D. The private right of action available to consumer for violations of this chapter or rules adopted pursuant to this chapter shall be exclusively as provided under the subsection. Subject to requirements coming up, a consumer who is harmed by a data broker or a large data holder. Okay, so we have two types of entities here. Data brokers, you know now what a data broker is. They're in the business of selling data, right? Personal data, brokering personal data. And we have large data holder defined as 100,000 consumers in the last year. Okay, so those are the two, right? The only two entities that could be held privately liable by a consumer. And not just that, but then you have really two portions of the bill that are open to the PRA. You have section 2419C and then 2425, which is the health data controller. So let me go up to 2419C. So 2419C, a controller shall not process sensitive data, except when strictly necessary, sell sensitive data, discriminate or retaliate against a consumer. We read these, right? But these are process personal data in violation of state federal laws. So when you're looking at the PRA, just keep in mind that it is limited to those violations only, and only if the entity is a data broker or a large data holder. Back down to 2424. I should have noted what page I was on. Thank you.
So the one that we had last time, and I can't think of the name, but it had $1,000 and this one has $5,000, correct?
Yes.
So, okay.
The data broker bill? Yeah. So if one of those sections or subsections are violated, a person, individual consumer, may bring action in superior court for the greater of 5,000 or actual damages, injunctive relief, punitive damages in the case of an intentional violation, reasonable costs and attorney's fees, and other relief the court deems proper. No action may be taken. So we have kind of a more of a narrowing here. No action may be taken under subsection 2461B, which is this. Sorry, that's the private right of action. 2461 is the Consumer Protection Act private right of action. No private right of action may be taken for a violation of any provision of this chapter or rules adopted as put in this chapter other than what is specifically permitted in what we just said, those two sections, or against a controller that is registered in the state and that earned less than 25 million in revenue in the previous calendar year. So again, you kind of have a narrowing here. It's data brokers and large data holders, but now they must be registered, out of state, and have earned more than 25 million in revenue in the previous calendar year. These are the only kinds of entities subject to the private right of action.
I may have missed this on. Registered in the state, is that a separate register or just general?
It's a business.
Secretary of State.
It's registered as a business in the state, yeah. So it could be, it's a good question, actually. It could be a data broker that is registered, or it could be as a foreign entity doing business in the state as a foreign entity. That would also be registered in the state. Very important to think about these things, yeah, because if you're a company that is incorporated in Delaware or something, but you have done things the right way and you register in Vermont as a foreign, I forget the exact term, but a foreign entity doing business in Vermont, would you be registered? I would say yes. We can define that. If you don't want to allow that, we would have to maybe work on that language a little bit.
Oh, I see. And is registered and, right, I got it. Okay, John?
And if you're a bad actor in Delaware who makes less than 25 million, you can register in Vermont and
You would not be subject because you make under 25 million. That's right. Both have to be true.
both have, yeah.
And then you also have to be a data broker or a large data holder. Right. Okay. So subject, we're still in the PRA. At least 65 days prior to filing of any, so let's say you meet all these things, right? You have found a data broker that is not registered in the state, that makes more than 25 million in revenue, and they have violated the law, right? So you have met the current requirements. But at least 65 days prior to the filing of any action, you must once notify the AG of the alleged harm in a form and manner prescribed by the AG, which at minimum shall require the name of the consumer and a reasonable description of the alleged violation and harm suffered, and mail to the alleged violator a written demand letter that identifies the consumer and reasonably describes the alleged violation and the harm suffered, unless the alleged violator does not maintain a place of business in Vermont or does not keep assets in Vermont. Within 65 days after receiving notice, the AG shall review the alleged harm to determine whether the claim is frivolous or non-frivolous. If the AG determines that the claim is frivolous, the Attorney General shall notify the consumer in writing, and the consumer is prohibited from proceeding with an action, a PRA action. If the AG determines that the claim is non-frivolous, that it has merit, or does not issue a determination within 65 days, the consumer may proceed with a claim. So that's the PRA. Mr. Chair, I think you have a question.
You have the right to sue no matter what, right?
Well, yes, but if the loss,
Even underneath this one, you get all the extra money.
so if you're suing, if you claim that a controller has violated this law, you are limited in suing in what the law provides you. So if the law says you can sue, but these are your ways you can sue, then that's what you can do. If you're harmed in a different way, that's not subject to the law, of course you can sue, right, for something else if they harmed you in some other way. Yeah. But we're creating, maybe kind of as a more foundational, we would be creating a law that is not currently in existence. So currently, there's no federal law either, right? So it's state by state currently, where each state has their own data privacy law. So in Vermont, there currently is nothing requiring companies to do these things. So you can't really sue them, right? Or even have the AG do anything. So this would be creating a path to hold them accountable in this limited way. Subsection E, annually, on or before February 1st, the AG shall submit a report to the Assembly disclosing the number of notices of violation the AG has issued, the nature of each violation, the number of violations that were cured during the available cure period, the number of actions brought under subsection D, that's the PRA, the proportion of actions brought under subsection D that proceed to trial, the data brokers or large data holders most frequently sued under the PRA, and any other matter the AG deems relevant for the purposes of the report. Any questions about enforcement? Okay, so this is the consumer health data portion. Except as provided earlier, there's some exemptions that apply here, and you can go back and confirm who's exempt from certain things when it comes to consumer health data. No person shall provide any employee or contractor with access to consumer health data unless the employee or contractor is subject to the contractual or statutory duty of confidentiality. No person shall provide any processor with access to consumer health data unless the person and processor comply with section 2420. That's the duties of controllers. Use a geofence to establish a virtual boundary that is within 1,850 feet of any healthcare facility, including any mental health facility or reproductive or sexual health facility, for the purpose of identifying, tracking, collecting data from, or sending any notification to a consumer regarding the consumer's health data. Okay, section 2. So we're outside the statutory law being created. The public education and outreach AG study. The AG shall implement a comprehensive public education outreach and assistance program for controllers and processors as those terms are defined. The program shall focus on the requirements of this act, data protection assessments, enhanced protections that apply to children, minors, sensitive data, or consumer health data, a controlled obligations to law enforcement and the AG, methods for conducting data inventories, and any other matters the AG deems appropriate. The AG shall provide guidance to controllers for establishing data privacy notices and opt-out mechanisms, which may be in the form of templates. The AG shall implement a comprehensive public education outreach and assistance program for consumers. The program shall focus on the rights afforded to consumers, the methods available for exercising the rights, opt-out mechanisms, obligations controllers have to consumers, the different treatment of children, minors, and other consumers, the understanding a privacy notice provided under the Act, the different enforcement mechanisms available under the Act, including the consumer's right of action, and any other matters the AG deems appropriate. The AG shall cooperate with states with comparable data privacy regimes to develop any outreach, assistance, and education programs where appropriate. AG may have the assistance of the Vermont Law and Graduate School in developing education, outreach, and assistance programs. On or before December 15th, 2027, the AG shall assess the effectiveness of the implementation of this act and submit a report to this committee and the Senate Economic Development Committee and the Senate Institutions Committee with its findings, recommendations, including any proposed draft legislation to address issues that have arisen since implementation. So I missed something because I thought about this earlier. I must have skipped this. Let me go back real quick. I'm sure Rep. Priestley would have told me I skipped this. Yeah.
Here.
No, you were not here. You were not here. How did I skip this? It's because, so rewind. I went from definitions to exemptions. I skipped the applicability. And at some point I'm like, I must have skipped this. Anyway, so not only does the law exempt certain entities from, right, like states, local governments from the law, it's also, we have some applicability standards that says that, you must reach these thresholds to have the law applied to you. So, except as provided this chapter applies to a person who conducts business in the state or a person who produces products or services that are targeted to residents of the state and that during the preceding calendar year, 1, controlled or processed the personal data of not fewer than 25,000 consumers, excluding personal data controlled or processed solely for the purpose of completing a payment transaction, or 2, controlled or processed the personal data of not fewer than 12,500 consumers and derive more than 25% of the person's gross revenue from the sale of personal data. So I'm sorry I missed this earlier, but this is very, very important that you may not be exempt, right? However, if you're a business that would normally be covered by the law, if you are not controlling or processing the personal data of fewer than 25,000 Vermont consumers, then this law does not apply to you. Nor if you have less than that, but you derive, less than 25% of your revenue from the sale of data, it does not apply to you. So important to understand that we have some thresholds in place to ensure you're not bringing in companies that really this bill's not directed towards.
Can you help me square this up with the language around the exemptions from the private right of action or the entities
Yeah.
for which the PRA does not apply?
Sure. So good question. Keep in mind that we're talking about just large data holders, right? We're talking about data brokers.
Okay.
They're processing more than 25,000. Ideally, if they're not, if they are a data broker, but I can't remember. Do we define data brokers processing a certain number of, we don't, right? There's no threshold for a data broker. It's just that they're in the business of data. Okay. So, you could have a data broker that processes 20,000 people, right? So if they're not grossing a certain amount of revenue, then they would not be applicable. This law would not apply to them.
Are the consumers listed in lines 14 and 17 also residents of the state?
Yes. Yes. So this subsection B is about the consumer health data. Section 2425.
So these, the minimum thresholds, are they with respect to the number of consumers in the state or? Yes.
Well, it's so a consumer is a Vermont resident. So yes, it would be, yeah.
Okay, thank you.
Section 2425 and sections concerning consumer health data apply to a person who conducts business in the state or a person who produces products or services that are targeted to residents. So they don't have the same thresholds. If you are processing personal data of consumer health data, then you are, unless you have an exemption, then the law applies to you. There's not the same level threshold. Okay, back down to, we're almost there. We are on page 60 something.
64.
60, wow. Okay. The middle of 64. So here we are, this is a little confusing. We are in the future, you'll see in a second, kind of changing the thresholds. So as you recall, if the bill passes as written, the threshold would be 25,000 and 12,500. Later on, I'll show you when this would change. It would lower. The threshold would be 12,500 if you control a process not fewer than 12,500, or if you process not fewer than 6,250 and derive more than 20%. So we're kind of expanding the scope, right? And this is intended to make it easier. And once the law takes effect, maybe you're a newer business or maybe you're a smaller business, and you're not quite ready to comply with the law, so you're given some time. Section 4 on the last page, later on, we're again lowering the number to 6,250 from 12,500, and then 3,125 from 6,250, keeping the 20% of gross revenue. Okay, so here are the effective dates. This effective date section, we have to do that. And the public education outreach take effect July 1st, 2025. The meat of the bill, the actual Data Privacy Act, would take effect July 1st, 2026. The first applicability threshold change, going down 50%, would take effect a year later, July 1st, 2027. And that final applicability threshold removal, another 50%, would take effect a year after that, July 1st, 2028. And that is H208. It's not even 12 o'clock.
Just way too efficient, Rick.
That's what it is.
Any other questions for Rick? Tony?
Why the drawdown here, last part?
The final one or both of them?
Yeah, both of them. Why are we drawing it down?
I think, I'll let some witnesses speak to that, but I think the thought is that you don't want to bring in companies that maybe aren't ready to comply with this law. And the lower you make the threshold, the more companies will be yeah, applicable to.
I think it's more providing more time for education. So the companies understand what their obligations are, and especially these are much smaller businesses. So it's meant to assist them and to get ready for it, so. Okay. Very good. Rick, thanks.
We'll do it over again in
We'll see you- we'll see you after
my breath.
So committee. For one, so back in here after the floor. Go through F 71. And. We'll be done. So, 5.